5 seconds to go. Start. This is the least and lowest estate which can subsist in reality. It is in strictness not an estate, but a mere possession only. It arises when a person, after his right to the occupation under a lawful title, is at an end, continues having no title at all in possession of the land without the agreement or disagreement of the person in whom the right of possession resides. Thus, if A is a tenant for yes and his terms expires, or is a tenant at will and his lesser dies, he continues in possession without the disagreement of the person who is entitled to the same. In the one and the other of these cases, he is said to have the possession by sufferance, that is, merely by permission or indulgence, without any right, the law esteeming it just and reasonable, and for the interest of the tenant and also of the person entitled to the possession, to deem the occupation to be continued by the permission of the person who has the right, till it is proved that the tenant withholds the possession wrongfully, which the law will not presume. As the party came to the possession by right, the law will esteem that right to continue either in point of estate or by the permission of the owner of the land, till it is proved that the possession is held in opposition to the will of that person. Before adverting to the present facts and claims advanced by the parties, it would be appropriate to refer to certain pronouncements of this court where means profit, which is the mainstay of the interlocutory applications before us, have been awarded. The respondent has referred to Atma Ram Properties Private Limited versus Federal Motors Private Limited to submit that the landlord's claim for means profit is not maintainable given that no decree of ejectment stands passed by the concerned civil court. We may refer to the observations made in the said judgment, which are thus: the power to grant stay is discretionary and flows from the jurisdiction conferred on an appellate court, which is equitable in nature. To secure an order of stay merely by preferring an appeal is not a statutory right conferred on the appellant. So also an appellate court is not ordained to grant an order of stay merely because an appeal has been preferred and an application for an order of stay has been made. Therefore, an applicant for order of stay must do equity for seeking equity. Depending on the facts and circumstances of a given case, an appellate court, while passing an order of stay, may put the parties on such terms the enforcement whereof would satisfy the demand for justice of the party found successful at the end of the appeal. In South Eastern Coalfields Limited versus State of MP 2003 8 SCC 648, this court, while dealing with interim orders granted in favor of any party to litigation for the purpose of extending protection to it effective during the pendency of the proceedings, has held that such interim orders passed at an interim stage stand reversed in the event of the final decision going against the party successful in securing interim orders in its favor, and the successful party at the end would be justified in demanding compensation and being placed in the same situation in which it would have been if the interim order would not have been passed against it. The successful party can demand the delivery to it of benefit earned by the opposite party under the interim order of the High Court or compensation for what it has lost, and to grant such relief is the inherent jurisdiction of the court. In our opinion, while granting an order of stay under Order 41 Rule 5 CPC, the appellate court does have jurisdiction to put the party seeking stay order on such terms as would reasonably compensate the party successful at the end of the appeal insofar as those proceedings are concerned. Stop.